Good morning. This is John Callis, President and CEO of Castle Breckenridge Management. Today is Monday, January 9th. It's a pleasure and an honor today to introduce our guest speaker, Jon Epsten, Senior Managing Partner of Epsten Grinnell Howell, in practice for well over 30 years. Let's give a big round of applause to Jon.
Thank you. Thank you, John.
John's going to speak on, give us an update on what's new from the legislature and answer some questions. We look forward to your questions. Jon, it's all yours.
Great, thank you, John. It's a pleasure to be here today. We're going to cover some of the legislative highlights for homeowners associations. I'm also going to go over some hot topics, what I call practice pointers, to try to help you with the day-to-day operation of homeowners associations. It's gotten very complex. I would say when I first started in this business, it was fairly straightforward. While I've been doing it over 30 years and my practice has been pretty much limited to the practice of homeowners association, representing homeowners association, I don't know everything. I learn something new, it seems like, every day. I used to say that I knew everything, but I've learned I don't. I thought it would be a good idea to start this morning by going over some legislative highlights or lowlights, depending how you look at them. First of all, don't forget when you're doing your annual disclosures, some key points. Look at Civil Code Section 5300 very carefully, but also use checklists to make sure your annual disclosures are correct. We're seeing a lot of association managers missing certain aspects of those disclosure requirements. Also, bear in mind, in July of last year, there was a disclosure that was added that I have seen missed on several occasions already, and it's found in Civil Code Section 5300. And it's a real simple thing. It just says in 10-point type, you have got to put on a separate piece of paper whether or not the condominium association is FHA approved, and on a separate piece of paper whether or not it's VA approved. Very simple, but it's gotten by a lot of people because it came in mid-year last year. The other one of the hot issues right now, although I don't think it's as hot as everybody thinks it is that the legislature has tried to define maintenance responsibilities of exclusive use common areas. Many associations, CC&R, say, by way of example, that the homeowners have an obligation to maintain and repair and replace exclusive use areas. That's still in effect. The problem we have is where CC&R say that the homeowner has an obligation to maintain the exclusive use common area, but doesn't discuss who repairs it and maintains it. Well, the legislature helped us out. If the CC&R say that the owner maintains it and nothing more, the association has an obligation to repair and replace. So always look carefully at your CC&Rs, but if they're silent on maintenance and on repair and replacement, that obligation most likely is going to rest on the association and not on the homeowner. Can you fix that problem by doing a matrix and putting in your rules and regulation? It's questionable. It's better to do a CC&R amendment if you want the homeowner to be responsible for the repair, maintenance, and replacement of the exclusive use common areas. Pesticides. Everybody heard about the new pesticide law. I was reading this. Of course, I was thinking, what's a pest? And so what is a pest? And the statute says it's a living organism that can cause damage to property. Now, why do we have a pesticide law? Well, we had a lot of homeowners who were complaining that associations, their landscape companies, were just spreading all kinds of bad pesticides around their homes. And the legislature got involved. And they said that unless you're a licensed pest control company, there's certain requirements you have to meet. And for example, notice to the owners or tenants. In that notice, you have to define the types of pest you're trying to control, the name and brand of the product, a huge caution notice. It's like a paragraph and a half long, cautioning people about the product, how often it will be applied, the date and time of application, at least 48 hours notice on separate interest to the owners and to the common area. And again, this only applies if you're not a licensed pest control company. The notice has to be placed in a conspicuous place in the common area, or it needs to be provided by individual notice. Mailing it out to the owners is one way. If there's emergency situations, the owners can waive the pest control notice requirements. And so I'm sure none of you were thinking about this morning, but as I was driving here, I was thinking, if you have a landscaper who's not a licensed pest control person, and they're spreading out the pellets to kill the snails, is that covered? And I think there may be an argument it could be covered under this. Several of my clients who have their own landscape crews who apply their own pesticides are getting out of it. They're hiring professional pest control companies, and that's always a good approach because you have a lot of issues involving people who get sick from pesticides and whether or not those illnesses would necessarily be covered under the association's general liability policy. So my advice is get out of that business, get out of the pest control business, give it to the licensed professionals. Moving on, because the legislature wants to provide you with more work, there's a statute that requires the association to solicit information 30 days prior to the annual disclosure period from owners. And I guess they did this just to put more burden on the management and on the board of directors, is because I never really felt this was a big issue. But Civil Code Section 4041, and most of you are nodding, you know about it because you just are finished up getting your annual disclosures out. It requires the association make a solicitation from the homeowners. And that solicitation is requesting from the homeowners where their notices should be sent. A solicitation from the owners asking whether or not they have an alternative or second address that they may want things mailed to. The name of any legal representative that represents them. This typically will come up if somebody has a power of attorney over the particular unit or the operation of that particular condominium or planned development or home. Whether the owner's owner-occupied, rent it, whether the owner occupies it, whether it's rented, whether it's owned by the developer, whether it's vacant land. I mean, really? Now, why would you want rental information? Maybe you'd want that. That'd be helpful if you're getting FHA approval. Most associations are kind of shying away from the FHA approval process, but that information certainly would be helpful. Of course, that's assuming any of these homeowners fill out the form and send it back to you, right? Which is, we know they don't typically read newsletters, so you may not get that form back. If the owner doesn't provide the notices, the property address is deemed the address for notices. So again, this is important because the legislature has enacted this statute. It's also important when you're sending out notices to owners, whether it's CC&R violations, whether it's rule violations, whether it's notice of delinquent assessments, whether it's the assessment billing. Always err on the side of caution and send it to everybody. You're going to have to look to see whether or not they sent this form back. If they didn't and you have a second address, send it to the second address. It's better to be safe rather than sorry. Any of you have any associations that have gated communities? So some of you do. So the typical scenario in a gated community is that somebody in that community is being sued, and well, I shouldn't say a typical scenario. This scenario comes up from time to time, but not everybody in gated communities gets sued. But who shows up? The process server. And the process server, you get a phone call as the association manager from the front gate staff, and that front gate staff says, I have a process server here. They want to go to Mr. X's home, and should I let them in? Of course, you as experienced managers know, yes, if they show a driver's license, that you have to let them in. So the law expanded a little bit this year. If you have a fully staffed gate, which most are, any person can be granted access for the sole purpose of providing service upon the showing of a driver's license, plus one of these other items, which I'm going to discuss, but there was one added this year. If they show a driver's license and they're a sheriff or a marshal badge, or they're a registered process server or a private investigator, or the investigator's here's what was added, or the investigator, there's an investigator employed in the office of the Attorney General, county counsel, attorney, city attorney, district attorney, or public defender. Now, this does come up quite frequently, maybe once a month in our office, where we'll get the manager will have the gate person on one line, they'll be on the other line, they'll have us on the other line, right? What do we do here? Do we call the homeowner? Do we let them in? Well, you know the answer. If they show a driver's license and they're a private investigator or they're a police official, you're going to let them in. Do you pick up the phone? Do you tell that gate person to pick up the phone, let them know the process server is coming? I don't recommend that. There's no prohibition on it. What we have done in some associations is we've had the front gate staff accompany the person to the home or to the condominium unit, just to make sure the person is doing what they say they're going to do. Obviously, you're probably not going to have that problem with a sheriff or a marshal or police officer, but you could very well have that problem with a rogue process server. And some of those process servers have a tendency to be very aggressive. And it's all going to come back to you as the association manager and that gate staff if, in fact, somebody feels they weren't treated fairly by the process server. Why did you let them in? They were rude to me. They threw papers at me. You need to be involved in that loop. But be careful. Don't become too involved in that loop. You also may run into a situation where that person comes to the front gate and wants to know where somebody lives. That's a whole nother host of problems. If they know what they're doing, they should already know where that person lives. You may want to step back for a moment and not answer that question readily. My opinion is if the person comes to the front desk, front gate, they should know where they're going. If they don't know where they're going, they should be turned down and politely asked to come back until they provide the address, then you let them through. So be mindful that it's not as always as easy as it seems on its face. We have had several homeowners who have threatened the association, saying you had no right to let the person in, the person was rude, the person was threatening. If you have your staff there watching it, it's helpful. Now, you notice I didn't call this person in your front gate a security person. I cannot tell you how many times I'll go to board meetings, they'll say, well, our security person did this. And I said, really, you're on 300 acres here. It's not gated around the community. That you're calling your front gate person a security person. Yeah, they have a security badge, and we pay them that says security on their bill. Be careful of that also. And this is just a side note, has nothing to do with the legislation, but be careful with that. Because really that person's limiting access into the property, really. That's all they're doing. They're not providing any type of security. If you give that false impression to people, you could run into a problem. And that's true when you're budgeting. Maybe budget that service, that independent contractor, as a front gate staff person as opposed to security. And make sure the homeowners understand on the front gate that they're not providing security. I read an email this morning where the homeowner was very upset because their home had been broken into, and they called the front gate staff, and who showed up? The police, not the front gate person. Front gate person knew what they were supposed to do. When they got that call, they were not providing security to the project. They called the police. They did the right thing. But it's key to let the homeowners know that too, because a lot of homeowners don't understand it. So I hope that was helpful. That's some of the legislative highlights with my commentary. And I thought it might be a good idea to talk about what I would consider some of the hot topics, and feel free to answer or ask me any questions on this. I believe that one of the hottest topics we're facing today is the transient occupancy. You've got people moving in and out of communities and on daily, weekly basis. And it concerns me personally, being in this business as long as I have been, because it really kind of defeats the whole purpose of community associations. If you really stop and think about it, these were named community associations for a reason, because the goal of the originators of this concept wanted a community. Well, you have people coming in and out. It isn't exactly, it defeats the purpose of having a community. We do know a few things. We now know that the Coastal Commission is involved in this issue. Most associations have a restriction that says you can't rent or lease your condominium for less than 30 days. FHA has that requirement. But we see owners, hosts coming in and renting out for 2 or 3 days and trying to get away with it. In certain areas of California, the Coastal Commission has now said that those prohibitions may not be legal. Those prohibitions are going to be challenged. Fortunately, that hasn't arrived in San Diego yet. You have Carlsbad that said you can allow transient occupancy in one location, but not transient occupancy in another location. My opinion is your CC&Rs always prevail until somebody tells you otherwise. We are now seeing that this whole transient issue not only affects FHA approval, but it may affect other types of approvals with Fannie Mae and Fannie Mac. They do not like condominium hotels, and it is possible that some of this transient occupancy in the beach areas where you have 6 or 7 units, 6 of them or out of 7 are transient occupancy, that may equate to condominium hotels, so be careful. There's a very good white paper out there if you want to read more about this that's was put out by the Community Associations Institute, and they did a really good job summarizing it. One of the things that we do is when we have an association that has this problem is we monitor the Airbnb and VRBO site and to see whether or not the transient occupancy, and you got to jump on it quickly. Bear in mind that if somebody does have a transient occupancy situation ongoing, they're required to pay transient tax with the city. And there is a process if you go onto the City of San Diego's website in which you can investigate whether or not somebody, or ask to see whether or not somebody is paying taxes for their transient occupancy. Typically, we're coming down on these issues and violations of the CC&Rs on the occupancy, but also on nuisance. Some of these beach properties have been hit really hard on the nuisance issues. I got a call about 6 weeks ago that this group was catcalling people on the beach, yelling and drunk, and so it transcends more than just with your CC&Rs. It also can be a nuisance. Any questions on the transient occupancy? I'm going to move on to another what I consider a hot topic. Insurance certificates. We were all yes, Harold. Sorry.
Is there a concern that if you allow it, HOAs allow it, that they could be pushed into a profit status instead of a nonprofit, or
Yeah.
forced to bring it up to ADAs?
Great question. The question was, if the association allows it, if they invest in it, in essence, do they have, or does it affect their nonprofit status and also ADA requirements? One of these organizations has tried to put together a model that says, association, we can help you make money if you allow us the transient occupancy. And most of you are nodding your head, yeah, we've heard that. But yes, that could affect the income to assessment ratio, that could affect their nonprofit status. And a really good point is the ADA, the Americans with Disabilities Act. Now does the association fall out of the Americans with the Disabilities Act, or fall within the Americans with Disability Acts? Bear in mind that associations typically are not subject to ADA. Why? Because they're not a public accommodation. They don't solicit to the public. They may be, if they get into bed with one of these organizations, that may be seen as a solicitation for public accommodation and subject to ADA. The other thing, just digressing for one moment since you brought up ADA, be cautious also on this ADA issue, the American with Disabilities issue, because we see it come up when associations have community garage sales, when people outside the community brought in at the recreation center and the restrooms aren't ADA approved. We had an association get hit on that issue. And one that they haven't been, and maybe I shouldn't say this publicly, but associations have to be aware of it, so I guess I will say it. Polling places. Some associations have polling places. If they limit the polling place to their members, they're probably okay. But if they open it up to the entire community and they've got restrooms there and they don't have the necessary ramps and they haven't met the ADA requirements, they could be subject to the ADA requirements for accessibility. And from a practical standpoint, in this day and age, I think Association Clubhouse, from a moral, ethical standpoint, probably should be looking at more at accommodations for handicapped people. Let me get to talk about insurance issues for a moment. We grew up in this industry, and I grew up with a few of you in this industry. We felt very comfortable when we hired a contractor. That contractor was a good person. We didn't have to worry about them. They did work for us on all these other projects. That kind of morphed into requiring them to provide what's called a certificate of insurance. And a certificate of insurance is their proof of insurance. And you've all seen it. It's one page. It's a form. Your name's the name's in the lower left-hand corner, and usually it says you'll be named as this management association will be named as additionally insured. That particular document isn't worth much to you anymore as an association manager, and here's why. First of all, the insurance company has no obligation to you to provide you notice if that insurance is canceled. They typically will, or if it's non-renewed. Just because you have that certificate, it doesn't confer that right. Now, you can do that contractually with the contractor. If your insurance is canceled, you need to notify us. But what it doesn't tell you is it doesn't tell you whether there's coverage under those policies for association work. And it also doesn't have waiver of subrogation provisions with regard to workers' comp. And if we have time, I'll go into that. But what we have found out, much to some of you maybe even in this room, surprise, is a lot of these vendors we're using have condominium exclusions and they don't even know it. So how do you address that? Well, the easiest way to address it is to look at the policy and see if it's excluded, right? Do you feel comfortable as an association manager doing that? Well, maybe you get the policy and you send it off to your association's insurance agent. You say, this is the work we're doing. You tell us whether or not there's coverage under this policy. Another alternative is you get a letter from the contractor's insurance company addressed to the association, which says, I represent this contractor, I'm their broker, I represent to you that there's coverage. I think the safest way to do it, of course, is reviewing the policy. And some of these contractors do not want to give you their policies. But if it's a significant job, even if it's not such a significant job, looking at those exclusions is important. I will share with you that we had a contractor who everybody in this room, I would bet, had a very positive experience with. We use the contractor quite frequently. We asked for their certificate of insurance last year and a copy of the policy. We got the copy of the policy when it had just been renewed. We calendar them in our office. So it had just been renewed. And I'm sitting there eating lunch one day looking through this policy, and when I get to the last page, it says multifamily exclusion, no condominium homeowner association work, but you're allowed to work in one unit within a condominium per year. That's what the endorsement said. I'm going, whoa. One unit per year per association. I called the principal of the company. I said, are you aware of this exclusion? He went, I didn't hear the phone drop, but I sensed it was close to being right. He goes, no, can you call my insurance agent and talk to him? I said, well, why don't you get your insurance agent on the phone? This same insurance agent had been insuring this company for 15 years. Wow. They didn't look at the policy when the new policy was issued. This guy was panicked. He was in the middle of our jobs, probably some of your jobs, and the agent was able to take care of it, fortunately, but it was a random look by me that caught it. Oh. I do like involving the association's insurance agent in insurance issues. They really don't have, no offense or anything to any of them, they don't have a huge job. They contact you, they may have you fill out an application, they put it all together internally, they send it to you, the board signs off a policy renewed, right? Maybe it's time to put a little more burden on them. And that burden could be, we are entering into a contract, we have this policy, we're going to send it to you, and we'd like your opinions. I have found it very beneficial. I've learned a lot sending these policies to an educated insurance agent or broker. It's a very good educational process, which also, I will add to that point, I would have your insurance agent come to every one board meeting every year and meet the board, so that when something goes wrong with that insurance coverage, it doesn't fall on you as the association manager. Oh, we didn't have coverage for that? Oh, that piece of, that side of the project wasn't covered, which I had. I had the property description, listed all the addresses, left one off. The association had a claim. Association submitted the claim. The adjuster called me and said, we don't have that building on this policy. I called the agent. I said, they don't have that on their policy, on this policy. Your problem. Well, he said, the board got a copy of that policy. And I said, well, I hope you have a very good errors and omissions insurance policy, because they relied on you to make sure everything was correct. Always ask your insurance agents or brokers the questions, because if you don't ask them the questions, they don't typically have much of an obligation to watch out for you, although the good ones are always watching out for you. I don't mean to demean them. The good association insurance agents are always watching out for you. And they don't like that I say this, but I will tell you, is if in your shoes as an association manager, as a board member, I would get a letter from that insurance agent every single year when that policy is issued saying, this policy complies with the association's CC&Rs. Why should you have the burden? You're the manager, you're the coordinator, you're organizing everything. But just like I'm not an insurance expert, you're not an insurance expert, although the board will say you were their insurance expert when something doesn't go right. So be careful of that. So any questions on insurance? Or one question that comes up quite frequently is under the election process, and one that I think you need to be very familiar with is this issue of the qualification of directors. Every year this happens to one of our associations. You're on autopilot with these elections. They happen the same way every year. And the candidates' forms come in, everybody looks at them, board approves it, you do your thing. And then you find out when somebody gets elected that nobody liked, that person's been a tenant for 25 years and they've never owned there. Or they're not on title. And undoing that process can be very embarrassing. So I would really recommend when those candidate forms come in, you run title, you find out if look at the bylaws, if they're required to be an owner, make sure they're an owner. If they're not required to be an owner, they can run. So be careful of that. That's an issue that we have come up regularly, but not every day. The other thing you want to do is look at appointing your inspector of election early. And you all know that typically the ballot comes back to the inspector of election. That's all good. But bear in mind the inspector of election has broad duties. And those broad duties include determining the validity or invalidity of any ballots, to determine whether or not in essence, whether or not the election is being done properly. Well, those issues may come up as those ballots are coming in. You may get a challenge during the balloting return process. You will get a challenge in your career if you've been in this business. Someone will say somebody's not qualified or the ballot was improper, whether it's election of directors or a recall or assessment increase. Get that inspector of election in place early on by a board vote. Have the board appoint the inspectors of election. So any questions on that? Yes.
Okay, when they're appointing the inspector of elections, it's not an automatic, you know, your manager will do it for you. It's a separate contract, so to
Right.
speak. And third party, you have to check and make sure that their bylaws don't prohibit third party
Inspectors.
decisions or allow
Right.
the managers to be one, right?
Right, so what you do is whenever you're coming up on that issue, the inspector of elections, you want to go to your election rules. And you want to take a look at whether or not management can serve as the inspector of elections. I do have some associations that prohibit the management company from acting as inspector of elections, the inspector of election. If you have you brought up a good point, and the point was, well, you know, when do we go outside? When is the time to go outside and look elsewhere for inspector of elections? I think whenever you have maybe this is so obvious I don't need to say it, whenever you have a hotly contested election, it's always better to go outside. Obviously, if that election is if that hotly contested election is related to management issues or board issues, take it outside. But I don't think that many associations do that. We don't serve, I don't think the attorney should serve as an inspector of election. The attorney needs to counsel the board, and believe it or not, some of these issues do go to court. And you need your attorney in court. Your attorney will be disqualified if the attorney is acting as inspector of election determining the validity or invalidity of an election, or the validity or invalidity of a ballot, or whether or not somebody has the right to vote, or whether the return envelope signature couldn't be read. That's something that should be done independently. Certainly the management can do that. Just you have to look within yourself and say, well, am I going to be perceived by a court as being completely independent if something hot comes up, if it's contested. So,
Okay.
all right, how are we doing on time? Good? Okay. Time to wrap it up? Okay. So in conclusion, this business of association management, association law has gotten very complex. Many people say, you know, can we call the law firm? First of all, law firms who you have a relationship with, doors always open. I have no problem when you call me and you say, John, I need a second opinion. Most lawyers in our community all get along. We all have that open door policy. If you think you're about ready to make a mistake, or you get that gut feeling that you're doing something wrong, pick up the phone and say, attorney, don't bill me for this. I have a 1-minute question. And because that's what we're here for. We look at this as a partnership with the association and with management. It's a one partnership, and we're there to help you. Thank you.
Let's have a big hand for John.
Thank you.
Okay, John, you got a few minutes. We can maybe have a little Q&A on any other issues that people are thinking of today. What else? Anybody else? Yes, go ahead.
Bankruptcies. We have a property that's carrying on a 4-year, now it's litigious, bankruptcy issue, where the person's done back-to-back-to-back
Right.
bankruptcies with the purpose of, we think, avoiding getting a lien in place, avoiding getting a judgment, avoiding a foreclosure.
Yeah.
That's
So what do you do? So you've got a repeat bankrupt offender, and what you have to do is this is a business decision the board has to make. But what we advise boards do is we file a motion to prohibit them from filing an additional bankruptcy. Some people have this system very much in place where, I mean, they know how to do it. But over time, the bankruptcy court's only going to allow them to go do so much. But if the association sits there and does nothing, it can go on for years. I took one over probably 4 years ago. It had been going on for 3.5 years when we got it. Not one penny had been paid to the association. The owner was renting it out. The bankruptcy trustee didn't know it, wasn't paying his mortgage. It was terrible. The key is the board's got to make those business decisions. They cannot expect to get every penny back on every assessment collection matter. The key is to cut the loss. And you can file a motion. It's not an expensive process, but you can file a motion asking the bankruptcy court to prohibit the filing of any further bankruptcies and or allow for the recordation of a lien. Bear in mind, when a homeowner declares bankruptcy, there's an automatic stay. You can't touch them. And if you, even though you may not be on notice of the bankruptcy, if you go after a homeowner who's in bankruptcy with a stay in place, which is almost always the case, you're going to be subject to contempt of court. And I guarantee that's going to automatically result in somebody paying some money to the debtor who's in bankruptcy. And also you've got to be careful, another issue you've got to be careful about there is when somebody completes their bankruptcy and their debt's been wiped out, make sure it gets wiped out of everybody's minds and books and records. Because what could potentially happen is you keep that on your books and now they owe 5-6 months assessments and you accidentally include the previous months that have been discharged, the pre-petition amounts, violation of the bankruptcy stay, contempt of court, and you're in trouble. I mean, one association, I will tell you, just settled a case for $28,000 on a matter that, in my opinion, wasn't worth $28,000. You know, most of these cases are $500 to $2,500, but it was pretty brutal. I mean, it was the people knew that this person was in bankruptcy and were warned. So be very careful. I would not ever recommend making those decisions without the advice of counsel. There's issues on how to move forward on bankruptcy issues.